Takulandirani ku AMTV Malawi kuchimake kwa nkhani zenizeni. Ngati nkhani imeneyo kuno kulibe, dziwani kuti nkhani imeneyo ndi yabodza.
FDH Bank, thank you.
Thank you so much. You may take your seats. Our colleagues from FDH would like to welcome you to Parliament. I think you're appearing for the second time. Like we indicated earlier on, that in the event that we want more information, please leave your lines open, that we can invite you back to Parliament for you to provide information, the role that you played in the transaction regarding the sale of Amaryllis Hotel. We'll proceed in this manner. We'll allow other members to introduce themselves. After members have introduced themselves, then media will do the same. Then we'll give you space to introduce yourselves. Thereafter, we'll ask you to take an oath. Those who are going to speak, we expect them to take an oath so that everything is put into perspective for future reference. Other members, can we start the introductions, beginning with Mulanje Southeast.
Thank you, Honorable Chairperson. Through you, good afternoon. I am Buka Matemvu, representing the people of Mulanje Southeast constituency. Thank you, Honorable Chairperson.
Good afternoon, Honorable Chairperson. I am Pisiani Banet Nyondo, representing the great people of Kitipa Center. Thank you, Chairperson.
Through you, Honorable Chairperson, my name is Santiago Samson Piri, representing the people from Mulanje South constituency and a member of Public Accounts. Thank you.
Good afternoon, Chairperson. The name is Macpherson Waindalama. I'm from Jiladzo Nyungwi. Thank you.
Honorable Chairperson, my name is Geoffrey Onseo, MP for Chikwawa North. Thank you, Chair.
Chair, good afternoon. My name is Gerard Tasaukadala, representing the people of Blantyre Central constituency. Thank you.
Good afternoon, Chair and all my seniors. I'm representing the people of Mulanje West, Tejo Mankando, and I'm Patricia Galiad. Thank you.
Good afternoon, Chair. I am Amina Gajia, representing Zomba Sondoli. Thank you.
Good afternoon, Honorable Chairperson and Honorable Members. I'm Moira Fiona Matenje, Senior Parliamentary Counsel. Thank you.
Honorable Chairperson, good afternoon. Sangwani Piri, Chief Economist. Thank you.
Honorable Chairperson, I'm Isabel Tambala, Committee Clerk. Thank you.
Through you, Chair, representing the people of Longwempenu, this is Eisenhower Mkaga. Thank you. And Deputy Chairperson of the committee.
Us and colleagues from FDH, my name is Stephen Baba Malondera Kansiamo, MP for Lilongwe Nyanja constituency, and the chairperson of Public Accounts Committee. I also happen to be the chairperson, the Secretary General for AfroPac. AfroPac is a grouping of all public accounts committees in Africa. And I also happen to be the Treasurer General for SADC-OPAC. So Malawi is also a Treasurer General for SADC-OPAC. All public accounts committees in SADC, I sit in as a Treasurer General because Malawi is a Treasurer General. Having said that, allow me to give you space to introduce yourselves. After that, then we'll proceed to have an oath. Over to you, Controlling Officer. For today, we will address you as the Controlling Officer. I hope the CEO will accept that today you've given you that, but it's for the sake of this deliberation. Over to you, Controlling Officer.
Thank you, Honorable Chair and Honorable Members. I am Esnat Suleiman. I am the Head of Treasury and Investment Banking, FDH Bank. Thank you.
Thank you, Chair and Honorable Members. My name is Giuliano Godfrey Kanyongolo. I am a Group Head of Legal and Company Secretary. Thank you.
Good afternoon, Chair and members. My name is Arthur Yapua. I'm the Head of Risk and Compliance at FDH Financial Holdings. I am also the compliance officer for the group and the bank. Thank you.
Good afternoon, Chair and members. My name is Zindawa Mbekeani, and I'm the Senior Manager in Treasury and Investment Banking at FDH Bank. Thank you.
Thank you so much. Media, I see. Can you introduce yourself?
Afternoon, Chair. Mary Jakaza, and Commerce Radio.
Thank you so much. I know in the morning we had a good number of colleagues from media. Once they're around, they're free to walk in. I see our senior he was here, but we'll give him space to introduce himself as well.
Chair, thank you very much. My name is Vuakaunda, MP from Katabe Central, sir. Thank you.
Thank you so much, our senior, Katabe Central. Secretariat, can you proceed to administer oath? Controlling officer, take note that those who are going to support you in this presentation are supposed to take an oath. So those who feel they will just observe, they can't take an oath. But in the event that along the way you notice that no, anyone wants to chip in, then at that stage, we will administer the oath. But to be safe, the best is for all of you to take an oath so that when you're called to duty, you can stand and proceed so that we don't operate or oscillate in that way. Secretariat?
I, Esnat Chilije Suleiman, do solemnly swear by the Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth, so help me God.
I, Arthur Yapua, do solemnly swear by the Almighty God that the evidence that I shall give shall be the truth, the whole truth, and nothing but the truth, so help me God.
Secretariat, can you administer the oath? Because I kindly guide the controlling how to handle the Bible. Yeah, it has to be raised to a certain.
I, Arthur Yapua, do solemnly swear by the mighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth, so help me God.
I, Giuliano Godfrey Kanyongolo, do solemnly swear by the Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth. So help me God.
I, Zinda Wambekeani, do solemnly swear by the Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you so much, Secretariat, for administering that oath. Controlling Officer, I'd like to once again welcome you to Parliament because we feel there's more information that we need to give. I know it's increasingly becoming difficult for a person like me because every time I have an appearance of officers, about 80-90%, those of who have been called to appear, I happen to know them. But from the word go, I've allowed just to make sure that we do what we're supposed to do. In my appeal to all those that we had an interface, be at school, be at Unilever, be at Airtel, be it in politics or in business, not to take all these deliberations personal, like you've seen. Even yesterday, when I was not available, Public Accounts Committee proceeded to make decisions because these decisions are not from the chair. They are decisions which are arrived at by the committee. So that's an appeal. It was like yesterday, I was attending to the role of Secretary General of Afropac. I arrived this morning, but I didn't retire to bed. The moment I arrived, around 8:30, I proceeded to here to make sure that we attend to these things because these are issues of national importance. So my appeal is to all those who are appearing before the committee. It has nothing to do with the chair. It has nothing to do with individuals that you know or interface. This we're just doing for the sake of the country and as mandated by the law. So having said that, allow me to give you space, at least to give your submission, which is premised on the letter that we dispatched to you on the 22nd April, asking you to appear before the Public Accounts Committee. Over to you, Controlling Officer.
Thank you, Honorable Chair and Honorable Members. Indeed, we received your letter dated 22nd April to make a second appearance before this committee. And as was indicated in our earlier meeting by our Managing Director, as FDH Bank, we do understand the importance of this particular matter that we are dealing with. And as such, we make ourselves available to address any issues that you may require us to do so. With your permission, Honorable Chair, we would like to proceed in this manner. I would like my colleague, our Head of Legal and Company Secretary, to give a contextual background to the matter from a legal perspective, after which I would come in to also give a background to the matter, especially in terms of the activities that we carried out as a bank. And then thereafter, we'll address the 3 questions that were indicated in the letter that was submitted to us. And my colleague, again, the Head of Risk and Compliance, will address those matters. So we submit, Chair, for your permission to proceed in that manner.
Thank you so much. Your permission will be granted, depending on the fact that in your submission, as you're giving the background, be it you or the colleague from legal, dependent on the fact that you're going to touch on the banking and payment processing that occurred, as a custodian of the fund account, that's a pension fund, and the execution of client instructions. Which instructions did you execute? And if need be, kindly also provide the actual dates when you got such kind of instructions, because Parliament is a house of record, and we want to deposit all those records that 15, 20 years when we've left this Parliament, others can refer. And in your submission or summary, as you're giving the background, please guide on the due diligence and compliance, the KYC that we're undertaking. You may also touch on the response in terms of regulatory and investigative actions which the bank took, because we're looking at substantial amounts of money. These monies were transferred from your bank to a national bank. So we're expecting as a committee also to have a brief background on what actually happened in terms of interbank transfer, interbank fund transfers. Then we also handle on the emerging issues. If you do that, then we're good to go. Over to you, Controlling Officer.
Thank you, Honorable Chair. Indeed, within our address, we will ensure that we have tackled all those areas that you have raised. So I will therefore pass on to our Head of Legal and Company Secretary, Council Kanyongolo, to start the discussion. Thank you.
Thank you very much, Mr. Chair, and all honorable members. I must thank you for allowing us to proceed as proposed by our controlling officer. But also, I want to thank you for inviting us to come to Parliament for the second time. We know that you have a noble and important duty to discharge in the exercise of your lawful mandate, and that's why we honored the invitation to come. Chair, I do not intend to take much of your time. I just wanted to provide confirmation that we considered all the relevant pieces of legislation or the necessary laws that guide us in responding to you. So for instance, Chair, we are cognizant of your mandate, both emanating from the highest law of the land, the Constitution, but also the National Assembly Powers and Privileges Act. We are aware of the powers that this committee has under law when it comes to requiring entities like ourselves to provide information. Chair, we moved on to consider applicable laws like the Bankers Book Evidence Act, where again, there are situations where banks may be called upon to provide information to relevant authorities. And also the Data Protection Act, where essentially you will notice that there are some restrictions that are put in place by Parliament when it comes to handling personal data. But of course, we also noticed that in the same act, there are some avenues where entities are allowed to discuss with various entities, law enforcement entities, in order to process the information of data subjects. Of particular importance, Chair, you may notice that we have a duty under the Act, the Data Protection Act, to make sure that where we see that there's an allowance which is being granted to, let's say, a bank to disclose some confidential information, we also have a corresponding duty to make sure that we should not overly neglect the rights of the data subject. So we're supposed to involve ourselves in data minimization. We are aware that to you, honorable members, the information that we may have submitted, you are going to treat it confidentially. But we know also that there are members of the media, the information will go public. So where we suggest that we should involve or indulge ourselves in data minimization, we ask that honorable members should understand us in that regard. Chair and members, we did not stop there. We looked at the duty of us bankers in relation to our customers, the duty of confidentiality. You may agree with me that this is not a new idea when it comes to banking law. It is a very old principle. We are supposed to treat the information that we have from our customers in a confidential manner. However, I must add that nowadays, I think there is a move away from the strict application of the duty of confidentiality. I think there are a lot of things that have happened in the progress, in the development of the law, that have made the makers of laws like yourselves to grant some leeways to entities like us to disclose confidential information. I can give you two examples. For instance, where strict adherence would maybe deter commercial transactions, entities are allowed to communicate confidential information. But also, in some cases, it has been noted that that duty of confidentiality sometimes is used as a cloak to cover wrongdoing. You may agree with me that from the times of 9/11 in the US. I think there are many amendments to our laws that have been effected to do with the transactions at hand, such that disclosure of confidential information, especially to law enforcement agencies or the government, is permitted. I wanted to say that there are several instances where even the law itself, common law, decided cases have granted leeways for disclosure. So, for example, where there's a requirement from law, a lawful order, you're supposed to do that. Where there's a public interest in a matter, you're supposed to disclose. Where the bank maybe wants to protect itself or to protect its customer, and there's a duty to disclose information, you need to disclose so that you can afford that protection to your customer. Chair, we finally looked at the Financial Crimes Act. I think this is our major piece of legislation when it comes to issues like the one that we are handling at present. You will notice that under the Act we have reporting obligations, several reporting obligations. Firstly, we have a duty to report suspicious transactions to the FIA, Financial Intelligence Authority. We also have duties to report, especially when we're doing, in the course of our banking relationship, when we're doing some customer due diligence and we've encountered a certain problem, we have a duty to report. But also when there are some specific requests for information from the FIA, we have a duty to report. I must hasten to add, Chair, that in the Financial Crimes Act, there's an important duty that has been placed on reporting institutions like ourselves, like the bank. So in relation to confidentiality issues, there's a clause, a section in the Act which says that if, for example, us as a bank have formed an opinion to say that this transaction is suspicious, then we have a duty first to report to FIA. But if we do that report, we cannot tell anyone else that we have made a suspicious transaction report to FIA. That is a very well-known principle. It's called, actually, if we did that, would be committing an offense called tipping off. And tipping off is a well-known principle globally, and in the very many treaties that we've entered into as a country, you will notice that it is recognized. But suffice to say that, as I've presented to you, Chair and members, we have avenues in which some of the information of customers, confidential information, can be relayed to the necessary bodies. And it is just an additional requirement of the law to say that those who are charged with the information then should handle that information in the manner prescribed in that law. So, Chair, I said I would not take most of your time. I hope I was brief, so allow us to continue as indicated by our controlling officer. Thank you.
Thank you so much. In fact, you've given us proper heads up in terms of confidentiality of customers, maintaining integrity of the bank, at the same time protecting the nation when the issue is in the public and has generated public interest, which is exactly what has happened in this case. So many thanks. Let's proceed to hearing from the controlling officer.
Thank you, Honorable Chair and Honorable members. I will now give some background relating to our role in the transaction. As you may be aware, we are the custodian for Public Service Pension Trust Fund, and we have been acting in this capacity since the year 2018. We hold 4 accounts for Public Service Pension Trust Fund. These accounts are operated by their various service providers that they have also engaged. We have an administrative account which is opened and managed by Samara Pension Administration Services. And then we have 3 custodial cash accounts, which are managed by the various pension funds, being Nico Asset Managers, Old Mutual Investment Group, and Continental Asset Management. The investments that the fund makes through these accounts are done through the fund managers, who are the ones who have the mandates over what happens within these accounts. So in that regard, whenever there is a transaction that needs to be executed, an instruction will be sent to us from the respective fund manager. And as per our required due diligence, we will require them to also provide to us supporting documentation to justify the transfer of the funds that has been requested to us. So with respect to investments, we do not deal directly with the fund, but we deal with these service providers that opened these accounts and are mandated to carry out transactions from these accounts. In respect to this transaction, we received instructions from one of the fund managers, Old Mutual Investment Group. The instructions came over 4 days. So we had an instruction that came on the 12th, another instruction that came on the 13th of January, another instruction came through on the 16th of January, and the final instruction came through on the 21st of January. And the amounts were to be transferred to Yusuf Investment Account, which is held at National Bank. We also received fund transfer instructions from Continental Asset Management, which came through 2 separate transfer instructions. One came through on the 12th of January, and the second came through on the 14th of January. And the instructions were to settle the funds into Yusuf Investment Account, again held at National Bank. These transfer instructions have been shared with members of this committee. We credited the amounts as instructed into the account that we were again instructed to. As per our process and regulation, we verified the signatures of the transfer instructions, and these were found to be in order. We also obtained supporting documentation to substantiate the transfer that was being requested. We were provided with a signed board resolution. We were also provided with a signed sale agreement. And we were also provided with records of negotiation on the terms of the transaction. And again, we have shared these documents that we received with the committee. These documentation were sufficient for us to execute the instructions that we received from the fund managers, and we then proceeded to transfer the amounts to the beneficiary account that was indicated on the transfer letters. Honorable Chair, on 26th March 2026, we received a directive from the Reserve Bank of Malawi requesting us not to process, authorize, facilitate, approve, or transmit or execute any further payment instructions issued by or on behalf of Public Service Pension Trust Fund in relation to the purchase of Amaryllis Hotel Limited. And since we received that directive from the Central Bank, there have not been any further settlements relating to this transaction. Honorable Chair, that is the background and the order of events. We will now proceed to address the specific questions that you raised to us, and my colleague, our group head of risk and compliance, will attend to those questions. Thank you.
Thank you so much. Let's proceed.
Thank you, Honorable Chairman and the honorable members of this committee.
We received the letter from the committee, and there were 3 questions that we are basically supposed to tackle today. So the first question was to brief the Commission on whether the bank reported to law enforcement agencies, such as the Financial Intelligence Authority or the Reserve Bank, in relation to the Amaryllis linked transactions. Chair, let me start by taking you back to the background which my colleague has given in terms of the due diligence processes that we carried out as a bank before we actually made those payments to the beneficiary account. Chair, as my colleague also said, we as a bank, we are regulated and we follow some of the acts that we, when we were processing transactions, for example, when you are establishing business relationships, we actually need to make sure that we follow with those laws and regulations. In this aspect, the Financial Crimes Act is paramount, and Section 16 requires banks and other financial institutions to actually, before entering into a business relationship, before carrying out a transaction, to make sure that we understand what the transaction is all about. We obtain all the supporting documents giving us comfort that the transaction is valid and legitimate, and we carry out confirmations, be it with the signatories, and ensure that the amounts that have been are indicated, they're actually going to the right beneficiary. That's the process that we do before, or which can actually tell us whether we are dealing with a suspicious transaction at that point. Section 23 of the Financial Crimes Act, it actually tells us that it stipulates that you need to, before you report a transaction to the FIA, you need to establish suspicion, or you need to have evidence that there is a crime which has been committed, or you suspect that there is a crime which has been committed, and then you report to the FIA about that crime. Specifically, looking at these transactions, we looked at the nature of the instructions that we received, and in our processing, we did not deem these transactions to be irregular. There are some points backing that assertion. The first was that the instruction to transfer the funds, these were sent by fund managers. As my colleague said, there are fund managers who sent instructions on respective dates, which she provided. So we received those instructions, and these are as per the mandate of the fund managers. These fund managers, I must add, Chair and members, that these are prudentially regulated institutions by the Reserve Bank of Malawi, and we, as a bank, we actually have comfort when we're actually dealing with other prudentially regulated entities. When you look at the transfer instructions, as we are doing the due diligence process, we confirmed that the instructions were actually signed by duly authorized signatories, and we also confirmed that those instructions are actually legitimate, and they are actually they have been made by the fund managers. When you also look at the nature of the transfers, these were in line with the mandate or the purpose of the account, which is to facilitate investments that the account will make from time to time. Again, when we looked at the transfer instructions, they were actually accompanied by sufficient supporting documents that proved that the fund managers were acting within their mandate. And we based on this, we based that assertion based on 3 documents. There was the resolution passed by the PSPTF to acquire the asset, which we've shared with the committee, the sale and purchase agreement, as well as the record of negotiations on the terms of the transaction. We also looked at the beneficiary of these funds to assert ourselves that it is indeed the right beneficiary and is the seller of the asset, and we confirmed from the documents that we were provided with that indeed these funds were actually going to this beneficiary as per the instructions. Again, when we looked at the fund, and this is public knowledge, the value of the fund is over 1 trillion. And these amounts that we processed as a business relative to that fund, or relative to that amount, were normal amounts that we've seen passing through the account when they're making investments, when they are receiving proceeds from investments. So as a bank, there was no basis to establish suspicion that these were fraud, or rather suspicious transactions, and report as such to the committee. I must also mention, Chair, that we received requests from institutions that are mandated to a request for detailed information on these transactions. Specifically, we received a request from the Reserve Bank of Malawi to provide account statements of the fund, of which we provided for all the accounts that we hold. This request from the Central Bank came on 18th March. We also received requests from the Financial Intelligence Authority, FIA, to provide again account statements to them so that they can do further reviews. This request came through on 12th March 2026, and we provided all that information to the FIA. So, Chair, in respect of the first question, that's the submission that I can make. I submit. Thank you.
Thank you so much, Controlling Officer and your team, for such submissions, and proceeding to attempt the first issue which was raised to you as a bank. Maybe before I open to other members, you did indicate in your submission that the transaction were normal because all the supporting documents were made available to you. And you indicated that there were signed body resolutions. When you're making your submission, you did indicate on that one. You talked of a sale agreement that was there. Did you, at any point, take time to go through the sale agreement? Controlling Officer?
Thank you, Honorable Chair. Yes, we did check the sale agreement, especially to verify the price at which they were transacting, so that we could align to the amount that were being requested to transfer. But also we verified the signatories of that sale agreement to also verify that the beneficiary of the account that we were transferring is indeed the partner in the agreement. Thank you.
Are you aware that in that sale agreement, there was a provision that 30% was the amount which was supposed to be paid in the first place? But when you look at the payments or the transfers which were made from your bank to National Bank, it's almost 92 billion. Now, when you take 92 in terms of percentage, comparing to 128, which was the sale agreement, in your view, does that conform to the 30% that was indicated in the sale agreement? Controlling Officer?
Honorable Chair, I can confirm that the amount paid does not equate to 30%. The agreement did stipulate milestones that would enable certain amounts to be paid. We're not privy to the status of those milestones, but we took confidence in the fact that the instructions that were being provided to us were being provided through the fund managers who act on behalf of the fund in terms of making the investments, and they do verify the stage at which the transaction is at. Thank you.
I asked that question because you submitted in the background that before the disbursement, you were aware of the documents, which include the sale agreement. What motivated you as a bank to proceed beyond the 30%, which is in the sale agreement, to proceed and pay 90 billion of the 128? When the sale agreement was very clear that 30% is the amount which was supposed to be disbursed. Did you raise an alarm if you had noted that there was that breach by yourself?
Honorable Chair, in terms of where we obtained our confidence to proceed with the payment is the fact that in terms of these specific accounts, we receive instructions in terms of amounts to be paid by the fund managers who are mandated to do so. The fund managers within their mandate are also advisors in terms of investments for the fund. And we are just a conduit for settling the payments. When we looked at the value of the overall agreement, it was above what we were making payment. So considering that we had received these instructions from the parties that are supposed to instruct us to make the payment, it was within our belief that the fund and the seller had arrived at the stage at which they could settle such amounts. Thank you.
There's a supplementary from the Vice Chair, and I see a hand from Mulanje Southeast, Chitipa Central, Mkatabe Central, Lilongwe, Vice Chair.
Thank you, Chair. Just wanted to get some clarification from the controlling officer. When you were explaining about the processes that you take to effect payment, you did indicate that accompanying the instruction to transfer, you had board resolutions. I just wanted to be clear, were these board resolutions by the board of the fund managers or the PSPFT?
Controlling officer, you can take that one. When we're done with that, we'll move to, there will be a follow-up from the Vice Chair. Then we'll move to Mulanje Southeast. Over to you, controlling officer.
Through you, Chair, I'll take the question from Honorable Member from representing Lilongwe Mpenu, who is also the Vice Chairperson. The resolution was a resolution signed by the Board Chairperson of Public Service Pension Trust Fund. Thank you.
Thank you, Chair. It has transpired in the course of this inquiry that some of the board members did not know about this transaction or the sale agreement until a meeting that was convened by the central bank. I just wanted to check with you. Did you check that the board resolutions contained the names of all the board members of the PSPFT?
Controlling officer.
Through you, Honorable Chair, in terms of our verification, and this might be different for various organizations, but the board chairperson carries responsibility and is able to sign on behalf of an entire board. And within that understanding, if a document is signed only by the board chairperson, it is considered to be valid. So when we saw that it was signed by the board chairperson, we took it to be valid. Thank you.
Now, in the light of the information that I've just laid bare before you, that some members of the board were not aware of the transaction, do you regret effecting the instruction, or do you think you could have done better?
Controlling officer? Be at peace. You still at your parliament. In the event that you feel that your colleague can supplement, you're free to do so. This is your parliament. Feel free and relax. In the event that you also want a break, you're free to raise a hand so that your parliament can remain accommodative as it has always been. Because we're not here like in a court. We just want to get information that is going to beef up to the inquiry that we're conducting, so that Malawians out there, those who trusted us with this responsibility, can have comfort. And those teachers, police officers, and public servants out there can have comfort that their future is secured. So feel free, relax, chill, then we get the required information. Over to you, controlling officer.
Thank you, Honorable Chair. My colleague, Head of Legal and Company Secretary, will take that particular question. Thank you.
Thank you very much, Mr. Chairman and Deputy Chair. I just wanted to put the matter into perspective, again, from a legal angle. So if you consider the nature of the relationship between a banker and his customer, you will notice that the banker is duty bound to honor the instructions he receives from the customer. So if you consider the relationship we had with the managers, they presented an instruction. And as my colleague in risk has ably detailed out, we took some steps aimed at verifying the legitimacy of those instructions. We first saw the sale agreement, we saw the board resolution, and probably the fact that these were instructions coming from a regulated entity. Chair, there's a reason why we are emphasizing that these were regulated entities, because under financial crimes legislation, we are called upon to invoke simplified requirements when you're dealing with regulated entities, because they are also answerable to their regulator, the Reserve Bank of Malawi. So when you consider all these things that we put in place in order to verify the legitimacy of the instructions that we received, that's why we got comfort in executing the instruction. I must add that when we are honoring that duty, primarily bankers are not supposed to consider the underlying discussions that they may have, that their customer may have made with other third parties. But your duty is just to verify the instruction that you have received from your customer and see if it meets the requirements of the execution of your banking responsibilities. So we can still say that we found that the instructions were reasonable, especially considering that, as indicated by the controlling officer, board resolutions can take various forms. There are many forms in which you can reduce a decision of a particular committee. You can do it either through minutes, or you can have a board resolution signed by the board chair and the secretary, or the board members, or even you can delegate just to a company secretary, the board secretary, to just indicate that this is a certificate of a resolution from the board. So without wasting your time, Chair, we saw that the instructions were founded.
take the last follow-up from Lilongwe Mpenu so that we proceed to Mulanje Southeast. Lilongwe Mpenu.
Controlling officer, yes, we do agree that resolutions basically would be an extract of the proceedings of the meeting, in this case, a record of which is the minutes. And ordinarily the minutes will contain all those that attended the meeting, whose record is reflected in the minutes. So, from this experience, don't you think that as bankers, you needed to be more careful? And again, you did indicate in your response that you trusted that this was coming from a regulated institution. And through this inquiry, it has also transpired that the regulated institution defied directives from the regulator. And in this case, you could not just rely on the fact that this communication was coming from a regulated institution, because we have proven that the regulated institution defied the regulator.
Thank you, Lilongwe Mpenu. Vice Chair, over to you, Controlling Officer. Take note that you've handled one question, then we'll proceed to handle that one, then we'll go to the next one. But you can address the one from the Vice Chair for now.
Thank you, Honorable Chair. Indeed, as you have highlighted, to indicate that there was an anomaly in the sense that not all members of the board were aware, or the trustees were aware of this transaction. However, if we look at the due diligence that we undertook as a financial organization, in itself was sufficient and within what we are supposed to do. When you look at it in hindsight, it can always go deeper and deeper and deeper. But as a regulated entity, there's a level of due diligence that we're supposed to undertake, and we undertook that level of due diligence. And as per our mandate to execute instructions that are provided by our client, as long as they provide the necessary information, we were also required to honor that instruction that we received on the basis that they did provide sufficient information for us to execute. The information is no different from other information that they submit to us in support of other transactions. And therefore, on our part, we followed the process and procedure and level of due diligence that was expected of us as a bank. Thank you.
Mulanje Southeast, over to you.
Thanks so much, Honorable Chairperson. Just to state that I appreciate the level of detail that has been given by our colleagues from FDH Bank. Not to undermine them, I just wanted to understand why, through your due diligence process, you got the attachments that you have talked about, the board resolution, the sale agreement, and the sale resolutions. I thought that the idea of you getting those documents was to ensure that you would use them as part of your due diligence. And as part of due diligence is not to get the documents on face value, but to actually understand what the documents are talking about and to marry what the documents are talking about vis-a-vis the transactions that are being undertaken. And that's why this honorable committee is having an issue with yourselves. To say that here you are, as part of your due diligence, you have asked for a sale agreement that you want to run away from and say, no, it's not our duty to look at the sale agreement. But because, these are regulated bodies and the instructions were duly signed, we have been dealing with them all the time, yet you are aware of why the Financial Crimes Act came into effect. It's basically to manage transactions that would normally say, these are normal transactions. Because within the transactions that we say, these are normal transactions, is where people hide the financial crimes transactions. So here you are as a bank, a renowned bank for that matter, calling for these documents. And for the record, Chairperson, we just want to ensure that our colleagues from FDH do assert that the board resolution that we're talking about here, for the record, was signed by the board chairperson alone. And we want to ensure that for the record as well, we get the date of the board resolution. The board resolution signed by the chairperson alone. We also want to ensure that we get the date of that particular board resolution so that we can marry it to the record that we have as to when the board sat and when these resolutions are expected. Secondly, Chairperson, I think we having an issue with you because having this sale agreement that says that there are particular milestones that are supposed to be met before further payments are made arising from this sale. And as far as we're concerned, the first payment was supposed to be 30% of the... are you aware of the milestones? Did you look at the milestones? Because if you were aware of the milestones that were supposed to be achieved to effect the next payment above the 30%, you would have realized that something was off. Between the 12th of January and the 26th of January, if through your due diligence you had looked at the milestones that were supposed to be achieved, what the sale agreement said that after the first 30% has been paid, the initial payment, what was supposed to be done to effect the next 40%, you would have realized that something was off. Lastly, Chairperson, I just wanted to find out from FDH, have you seen the press release from the financial regulator, the Reserve Bank of Malawi, revoking licenses of those that were sitting as trustees of the fund? If you have not, we would want the Secretariat to help furnish our stakeholder with that press release so that we can get an interpretation from them, because they have been relying on regulated bodies. And we want to find out from you why the regulator of regulated bodies, in this particular instance, is revoking licenses of trustees of the Public Pensions Trust Fund. Honorable Chairperson, submitted. Thank you.
Thank you so much, Mulanje Southeast, for such submissions. The question, over to you, Controlling Officer, to attend to the question from Mulanje Southeast.
Through you, Chair, I will address the questions that have been raised by Honorable Member representing Mulanje Southeast. The first one to do with why we get the documents and why we did not go further. Chair, if I were to put it in perhaps a different kind of scenario where we have an individual who is a customer of the bank and they would wish to buy a house and they submit to us the transfer instructions to say that I would want to buy this house, you agree with me that as a bank, will not go and question them, why this house, why not the one in Chinyonga, why are you agreeing with the seller to buy at this price? That would be in perhaps a more simplified environment. Now, coming to the case of our client, Public Service Pension Trust Fund, it is also not within our mandate to question the investments that they're making, because they have other advisors who are the fund managers who are responsible for making investments. They are the ones who will do a due diligence on the investment. So if they, the ones who are supposed to do a due diligence on the investment, then issue us with an instruction to proceed with the transaction, it is not within our mandate to question. The reason we would get this supporting document is to, one, verify that indeed they, the fund managers, are also acting within their mandate provided by the underlying client who engaged them to go into these respective transactions. And so in verifying, as I indicated in my earlier response, we verified in line with our mandate to the extent that we can verify. We cannot question details of a transaction to say why this price, why this seller. It is not within our mandate to do so.
Maybe before you proceed, you may recall that when you first appeared before this committee, you told this inquiry that you were once hired by NICO, that you could do a business valuation for the same transaction. And in 2023, you indicated to this committee that having done all the valuation, you were hovering around 25 billion to somewhere around 50 billion in terms of business valuation. And you went on to indicate to this committee when you appeared then that at that price, it was not viable business, according to the indications or the submission you made when you first appeared regarding you being hired on the same transaction. Now, 3 years down the line, in 2026, you have an opportunity to make a payment on the business that you had recommended that, no, this is not viable at between 25 billion and 50 billion valuation that you had made in 2023. Did this not in itself, knowing that now you've gone past that 50, which you had recommended that, no, this is not viable. Now the same customer is coming to you and telling you, no, can you pay this, and it goes beyond 50, it's now at 90 billion. And you proceeded to pay because you're saying there was no need to question anything. Did this raise an alarm that, no, wait a minute, can we report this, can we check on this, or to have proper detailed due diligence on the documents which were presented to you? Because earlier on you had that privileged information that you had undertaken a valuation, business valuation of the same business, that 3 years down the line you were able to facilitate the payment of 90 billion. Did this raise a flag to the bank or not? Controlling officer.
Thank you, Chair. Indeed, we did conduct evaluation of the business in the year 2023. Perhaps I must also indicate to say that the capacity in which we carried out that business valuation was a different capacity from the custodial capacity that we used to settle the transaction. In our business valuation, we provided an indicative value of the business, and as is the case with every valuation, it is merely a guide on what we believe to be the fair price of the business. However, there is always a disclaimer that states that the final price is arrived at through negotiations between a willing buyer and a willing seller. Honorable Chair, our valuation was also done in the year 2023. This transaction was, if we look at the agreement, was signed in 2025. A lot of things may have changed from the time that we carried out the valuation. And at the time that we carried out the valuation in 2023, we were requested to carry out the valuation by the fund managers, who are the investment advisors, who were then responsible for the underlying due diligence. We were merely providing a price. At the time of settlement, this transaction has again been settled using instructions from fund managers, whom we believe must have also carried a valuation at the time of transacting, and that price was guided by evaluation. So from our mandate, we could not have questioned someone else's valuation. These are technical expertise. People have different expertise. They have done their valuation. We do not know the information that was used to carry out that valuation. So at the face value, we cannot say that this value is wrong or right. The documents that we submitted to you, there was also a record of negotiations that took place. And as indicated, to say that even when we do valuations, we say that the final price will be determined by negotiations. And they showed us to say, well, we negotiated, and this is the value that we arrived at. We cannot dispute what the client and the seller agreed to transact at. Thank you, Chair.
So much. You may proceed to take, I see a hand from one of our colleagues. Please proceed.
Yeah, thank you, Chair. Just a supplementary on that, and to put it into record, in our valuation, we did not come with an opinion to say whether the business was viable or not. We merely provided a value so that whosoever is doing a due diligence will use that value to determine the negotiating price for the asset. So in valuation, we don't ascertain whether the business is viable or not. You are just merely providing a value as far as that business is concerned. Chair, I just wanted to put that into record. Thank you.
Thank you. There's a point of order from Mulanje's office. What has gone out of order? Mulanje's office.
Honorable Chairperson, I think we are being misled here. The last statement that has been made, that the business valuation that was done by FDH did not provide an opinion as to whether the business was viable or not, is misleading your honorable committee. Honorable Chairperson, thank you.
Controlling officer, you were the one who made such a presentation. Can you retake that one?
Honorable Chair, in terms of the evaluation report that we submitted, we indicated that the value that was determined was below the value of the net asset value. And we indicated to say this is because the proceeds from the business itself gave us a value that was lower than the value of the net asset value. So this was mainly because of the value of the property itself. So there's a different value, which is the value of the business and the value of the property. So what we were saying is, as a business, the value was lower than buying the business. So our opinion was on the value and not necessarily on the viability of the business. We merely stated that the business itself generated a lower value than the value of the property. Thank you.
Thank you so much, Controlling Officer. I see Mulanje's office. Please proceed.
Maybe the stakeholder is forgetting, and that they be reminded that this honorable committee has the memory of an elephant. It doesn't forget at all, because the submissions that were made before this honorable committee were recorded. And the stakeholder actually told this honorable committee that as far as FDH was concerned, they did not see the business being valuable for the next 40 years. And that's on record. And for them today to retract that opinion that was provided on record is misguiding your honorable committee, honorable chairperson. Thank you, honorable chairperson.
I see Chitipa Central. Thank you so much, Mulanje's office, for refreshing the controlling office and the team. I think they've taken note, Chitipa Central.
Let me yield.
Thank you so much. Controlling Officer, I see a hand from your colleague. Kindly take to the floor.
Yeah, thank you, Chair. I know the records were straight, and I also remember watching the proceedings. And I think the ones that did the due diligence in terms of payback period were Continental, because they came into this house to say, we found out.
Honorable Chair, if I recall, the second question was to do with the date on which the resolution was signed. The resolution was signed on the 25th of October, 2025. He further asked with regards to whether we have verified the milestones and whether they have been met. Honorable Chair, I would still like to take you back to our earlier response with regards to the difference in our role as custodian and the role of the fund manager that issued the instruction to us. The role of the fund manager, they are the advisors of the funds, of the client, and they are the ones that execute the investments. Verifying the milestones was not within our mandate as a custodian. This is something that would sit within the mandate of an advisor. So, in response to whether we verified whether each and every milestone was met, I would say that we did not, because it was not within our mandate to verify that. And then finally, we were asked if we have seen the press release by Reserve Bank. I myself have not yet seen it, but normally being the custodian of the fund, the Secretariat always writes to us when there are changes at the board level. As of now, we have not received anything. I have also not seen a newspaper today, so I may have missed it if the press release was in the papers. Thank you.
Thank you so much, Controlling Officer, but just take note that it has been released, and probably tomorrow it may be in the papers, but it's circulating in the media, very clear and detailed. And this far, we haven't received any issues surrounding that, maybe from the Reserve Bank, indicating that it's fake. So as Public Accounts Committee, we would take it that it's an original, and it bears the signature of the Reserve Bank governor. So we will proceed in that manner. Can I take to Chitipa Central? After Chitipa Central, we'll go to Nkatabe Central. Chitipa Central.
Thank you very much, Honorable Chairperson. I had the same views of Mulanje Southeast when he was talking of sale agreements and other requirements that maybe the bank needed that just to tick the box. But then looking at, hearing at our counsel here, he's a very careful person. He's a very serious person. He has cited all the regulations. He even took us to America, talking about September 11. And then even our risk manager is a very careful person. They have talked about regulations that they can't give us information because the regulations protects them from doing that. Some of information that your honorable committee would need to help with, to come with informed report. But then when it comes to 30% requirement, suddenly they are not that very careful. Careful people don't forget things like that. Honorable Chairperson, being a fair person, my thinking would be the fund paid 30%. And out of the carelessness of the bank, they paid more. I would say, why shouldn't Chitipa Central ask that the excess of the money comes from the pocket of FDH? If the fund is going to lose money, then they should lose 27%. The rest 30%, which is like 27 billion. The rest should come from the pocket of FDH. So I wanted to give them a chance to say, why shouldn't we think like that, that the excess of the money was paid out of their own carelessness. The fund agreement allowed 30% payment for a reason, to protect their money. And the bank had a duty to protect that money. So why should we not think that, or demand that excess of the 30% should come from the pocket of FDH? I submit, Chair.
Thank you so much, Chitipa Central. Controlling Officer.
Thank you, Honorable Chair. I've noted the comment from Honorable Member representing Chitipa Central. To say that it was out of our own carelessness, we believe is, well, we would choose to differ on that, in the sense that we take instructions. We are a bank. We rely on instructions that we have received. We do not pay just out of our own will to make a transaction. And we were executing an instruction that we received, which was supported by documentation that proved that the owner of the funds, or whoever has responsibility over the funds, has approved that transaction to take place. As a bank, we are mandated to honor an instruction that we have received. If I go back to the example that I was saying, a more simplified example, for an individual, if an individual wanted to make a payment and we refused to make that payment, that individual will go to the central bank and complain and say, the bank has eaten my money. So we were supposed to honor the transaction. If you look at it from our perspective, we know that the amount appears to be significant, but if we also understand the financial muscle of the client, whose value is over 1 trillion, that is not as huge a transaction relative to the fund size. So on our part in carrying out our due diligence, that transaction was within the normal course of activities that that client carries out. This is not the first investment that it has made. It has made several investments through the same fund managers, and we have executed the instructions with the same proof of transfer that we got for this particular transaction. So we acted in the best faith and within the mandate that we're supposed to do for the client. Thank you.
There's a follow-up question from Chitipa Central, but maybe before I get to Chitipa Central, I see a hand from FDH. Can you take to the floor?
Thank you, Chair. A supplementary on that one. The issue of a sale agreement, you can see also in the submission that we've given you, there is a letter from Public Service Pension Trust Fund instructing fund managers to transfer the 90 billion, apart from the sale agreement that stipulated 30%. Now, in the pension industry, trustees are mandated to do investments of any value. You can see that any other investments end with the trustees. The board of trustees doesn't go beyond the board of trustees. So, with also that instruction from the board of trustees of Public Service Pension Fund to say, instructing the fund manager, it's in the submission, instructing the fund manager to pay 90.25 billion to Amaryllis as a first payment. We also relied on that instruction because the trustees are mandated to do any level of investment, because all the investments decisions ends with the body of the trustees. It doesn't go beyond them. So there was also, even though the sale agreement stipulated 30%, but there was also a letter that it's also included in the submission that highlighted that 90.25 be transferred. Chair, thank you. I just wanted to add that.
Thank you so much, FDH. Mulanje Southeast, what has gone out of order?
Honorable Chairperson, a lot has gone out of order. Is the stakeholder aware of complicity? When we say you are complicit in an act, do they know the weight of complicity? And for the stakeholder to come before the honorable committee, having proclaimed that they follow due diligence, as part of that due diligence, they got a documentation from the fund managers. And the documentation, as part of the documentation, there is a sale agreement. And that sale agreement stipulates when payments are supposed to be made. And he comes to this honorable committee and says, no, we disregarded the sale agreement. And we relied on an instruction that actually was at reverse, asking the bank or the fund manager to pay 90.2 billion against what was provided in the sale agreement. I mean, if the Financial Crimes Act actually stipulates that they have got a responsibility to ring bells, they are not a conduit. And the presentation that they're making to this honorable committee is that they're a conduit. If I say, please pay, they pay because I have told them. So we cannot go back to them to say you facilitated a financial crime. Is that what I'm getting from the stakeholder? Honorable Chairperson, thank you.
Controlling officer, you, like earlier on, indicated that in your due diligence, you engaged the board through signed board resolutions, and there was a sale agreement, and the sale agreement, like you indicated, because you're the one who raised the issue about sale agreement, I want to refresh to you that according to the sale agreement, there was a need to pay 30%. But in your case, you paid about 72% of what you're supposed to pay. 40% more. Basically, that's where Mulanje Southeast has issues. That you're picking issues to handle. On this one, you're trying to push it to the customer based on the instruction that you got that pay. But for you, you were in earlier on when you're doing your diligence, you had a sale agreement before you. That's where Mulanje Southeast has issues. Can you come out clear on that one, controlling officer?
Thank you, Honorable Chairperson. The sale agreement was for a total value of, well, after they negotiated according to the notes, they settled at 128.75 billion, which is the amount of the agreement. The amount that were requested to settle is below this amount. We take note of the milestones that were supposed to have been met. But as I indicated earlier, it was not within our mandate to actually verify each and every milestone. We would be going beyond what we're supposed to be doing as a bank. But we took comfort in the fact that the amount that we're settling is below the amount that they have agreed to sell. It's not one tambala above this amount. And in so doing, there could be many factors behind that could result in the 90 billion being paid. It could be that they did not pay when they met the first milestone. They paid later after attaining another milestone, because the instruction letter that we received was not a letter that said in respect of the first milestone. It was just a letter to say that they are settling the transaction. The advisors, in our opinion, would be knowledgeable of how much is supposed to be paid for the transaction, and hence advising us to settle. In respect of the letter that my colleague has also referred to, an instruction was also provided to say settle this amount. We could not question why they are saying to settle that amount. That amount is within the transaction price, not beyond. As to why, it is not within our mandate to question. Thank you, Chair.
Procedural.
Thank you, Honorable Chairperson. My follow-up is still on the 30% that they paid, that the excess should have come from their pocket, because I think it's a mistake. Maybe not a careless mistake, but a mistake. Or a deliberate one. It wasn't a mistake, if they don't make mistakes. I'm just looking at a scenario where I have $1 billion in their bank account. And in the internet banking, I'm allowed to transfer 50 million in a day. But then somehow I transfer 200 million and I lose that money. Will they claim that we got an instruction from you that you transfer 200 million and we proceeded? There's a reason why there's a limit to protect someone's money. And the reason of the 30% in the sales agreement was to protect the money. I would want to inform you, Chairperson, that I bank with FDH. When I do a lot of transfers, the bank will phone me. Your account has been transferring money. Are you the one? They are alerting me because they are afraid I can lose money. In this case, they say, no, we didn't alert anyone. We didn't report it to anyone, even though it was beyond the 30% in the sales agreement, because it was not within our mandate. Because the point here, the worry here is because they have not reported any suspicious conduct, because they see that in their due diligence, there was nothing suspicious. And in the due course, they pay more than what was stated in the contract agreement. And the argument is, we got instructions from the owner of the account. Now, if in that scenario I've given you, would they say that? Or I would be able to go to the bank to say, but then my limit is only 50 million. What happened to the other 150 million? And again, why do they alert me when I transfer 10 million? They will alert me because their wallet is suspicious that my account is transferring a lot of money. So, controlling officer, my question still stands. When you say, because you got instructions, if somehow your account has, not your account, your machines has somehow failed your bank and paid more than the allowable 50 million, which is allowed for me to pay, will you say, no, it's not our fault? That's my, I submit, Chairperson.
Controlling officer.
Honorable Chair, perhaps I can say two things in response to the question that has been raised by Honorable Member representing Chitipa Central. The first one is to say that with respect to the transfer instructions, which you have received from ourselves, those transfer instructions do not specify that the payment that we're making are with respect to the first installment. So if it had specified so, then we would have verified the value of what that first installment was supposed to be. But it was a payment to be made. At which point they were in the milestones was not within our knowledge. The second thing I can say, this instruction was coming from the owner of the funds. With respect to the example that you have given, to say that when we notice a lot of transactions going through for a particular client, we'll contact them because they are the owner of that account to verify. In our case, we had the owner of the account giving the instruction to pay. So we cannot question the owner to say, why should we pay your money to buy this when the business of that owner is actually to be investing? So it was, we acted within our mandate, yes.
The colleague from FDH as well.
Thank you, Chair. A supplementary, in terms of transaction volumes and values, where now we alert customers when there are some other transactions going, it depends also on the behavior of the account. For this account, it's a custodial cash account where investments are done every day. So there are investments in shares, investments in government. So it's a high volume transaction where such transactions are normal. But for a customer like me, for example, to be transacting maybe with those values, then you would wonder. That's why maybe there are some lifestyle audits and what have you. Because the values that I'm transacting at does not resonate to what is in my account. But now, in terms of Public Service Pension Trust Fund, they've been doing investments and they have massive investments for that matter. So that account has high valued transactions all the time. And that's why when the owner say pay this amount, so we know that the owner is capable because there are funds that the owner has put in that account. I should also just add to say these funds were not with FDH at the time of the transaction. They had to take these funds from elsewhere so that they can fund the transaction that they are transferring out. So in this regard, it's in this case where now I should give an example maybe to honorable member as well to say, I have a certain pending transaction and I've got money from elsewhere to fund my account so that that funded account then should be able to settle that transaction that I'm doing elsewhere. So that's what happened. The fund managers got funds from elsewhere to fund their account for this transaction to go through. So if we did not transfer, then we said, what about the funds that we've put into the account? Where are those funds if you are not transferring? Because we have funded the account specifically for this transaction. So that's the series of events. That's how it went, Chair. Thank you. I just wanted to add that.
Thank you so much. You just indicated that the account is a high volume account and all the time the account behaves in that manner. I wonder, is it all the time or most of the time? Because in this case, the money had to come from elsewhere. If all the time it behaves in that manner, what is it?
Sorry, Chair, it should be all the time, most of the time. Because when they are doing some large volume transactions, that's what happens. They will get money from elsewhere, maybe some other investments to fund a certain type of investment because that investment needs a huge outlay. So that's what happens most of the times. Thank you, Chair.
Thank you so much. I see, maybe before we get to Chikwawa North, there is Nkatabe Central. Nkatabe Central?
Chair, for recognizing me, I was wondering. Chair, I have two questions to ask. The first one is to clarify why FDH is here reappearing when in fact they appeared before to this committee. Why they are appearing, Honorable Chair, is the fact that the pension fund has been defrauded. Let's be clear and fair. One, Ndrama's Nabedo pension fund, that's a fact. The pension fund has been defrauded. And the channel through which the fund was defrauded is through National Bank and FDH. That's the issue. That's why you have been called to reappear. And don't be surprised if we call you again. Tell the MD. If we call you again, these are the facts. The fund has been defrauded through National Bank and FDH Bank. That's a fact. So the question is, I want to ask, there were instructions to the bank, and these instructions recorded for a board resolution. The board chairperson signed the resolution. The person signing was Mr. Chizaso Nyirongo. That was his name. The man who was issuing these instructions was Mr. Chizaso Nyirongo in his capacity as board chairperson. The controlling officer at the pension fund was Boyd Hamera, the controlling officer. These two were put there by Madam Colleen Zamba. That's the more reason why we say, with that Colleen Zamba, this inquiry banner cannot be concluded. We need Colleen Zamba to clarify these matters. Now look here. On the 12th of January, Chizaso Nyirongo, board chairperson, issued instructions to the fund managers. Can you pay out through Audi Mutual? Yeah? And then on the 13th, another instruction is given. On the 14th, and then on the 17th, up to the 21st. So between the 12th and the 21st, this 1 2 weeks, that's the only time all these transactions were taking place. Were you not suspicious? My first question. Were you not suspicious? Simnadabwe. We're not suspicious, honestly. Now here we are saying the pension fund has been defrauded. And these are public funds. These are not private funds. We had instructions from the owners. You are referring to the to Chizaso Nyirongo as the owners of the funds. How can Mr. Chizaso Nyirongo have 9 trillion in his account? Because the owners had given us instructions, so therefore we had to effect. My last question to perhaps observation. Last time when you appeared before this committee, the team was led by the MD or the general manager, yeah, Mr. Nkulichi. Where is Mr. Nkulichi here? I'm not trying to undermine you, but the issue is, look at the observation from Chitipa Central. Chitipa Central is now alleging that due to your negligence, you must now refund. The penalties must now come to the bank. Are you saying now? Where's the MD in all this? How do you defend yourself? Honorable Chairperson, I rest my case.
Thank you so much, Nkadabe Central. Take note that when they were making their submission, they indicated that there was a sale agreement, there were board resolutions. For us to come out very clear and say it was defrauded, I think that would be a sweeping statement. Maybe we can have another wait because there were transactions which were happening. I sit here as a referee. So as a chairperson, I think some of these things are supposed to be put into
There's a definition called theft by fraud or theft by tricks. Well, I know those things. Theft by tricks, theft by fraud. You can present a false document in order to take away money from the pension fund.
Thank you so much, Nkadabe Central. And take note as well that the instructions which were made according to the correspondence that we have, the instructions were coming from acting principal officer, who is Boyd Hamera, and when he appeared, he confirmed that such was the case. So I just wanted to put it into perspective and to maintain the record straight that it was acting principal officer who was sending instructions to be paid. There was nothing like anyone from the board making such instructions. I know as an inquiry, let us appeal as well to government because there's a need for government, especially the executive, to also perform specific functions when it comes to other officers who are not appearing before this committee. Like you've indicated, the former chief secretary, there's a need for government to move in because while we're conducting these inquiries, the lawyer for the former chief secretary indicated that she cannot appear because there's a warrant of arrest and this issue is in court. And that warrant of arrest emanated from the executive. I think it's an appeal that Parliament can make to the executive so that some of these things are put into perspective so that we can proceed procedurally because such a thing needs to be cleared. She must appear, but what has been written by the lawyer needs to be done. I think we can engage the speaker so that can engage the executive on how we can be guided going forward, especially with in consultation with our legal team, so that all those things are put into perspective. Controlling officer, you can take the other ones. Over to you.
Thank you, Honorable Chair, and thank you, Honorable Member representing Nkadabe Central. With respect to the question to do with whether we found the transaction to be suspicious, I would like to indicate that as a bank, we are a prudentially regulated financial institution. What we do is guided by the regulations within the financial sector. And with regards to our relationship with the client, it is also guided by the various service level agreements that we have with the customer. With regards to the actions that we took as a bank to verify the transfer instructions that we received, these were sufficient in line with what we were supposed to have done. So we carried out our work in line with what we were supposed to have done to the dot. Maybe there's a feeling that we should have done more, but that more could have just been voluntary, but not necessarily saying that what we did was not enough because it was in line with what we were supposed to do. As indicated, we have been custodians for this fund since the year 2018. And in that period, they have made a lot of investments. And the same due process that we followed is the same due process we have been following for all the other investments. And we have not been found at any point to be in breach of our responsibility as a financial institution that is regulated by central bank. So I would like to say that on our part, based on the reasons that were already provided, Chair, without having to repeat, this transaction to us was not suspicious. The instruction had sufficient supporting documentation. And when we look at the transaction versus the size of the fund and the transactions that are done, the nature of the investment is the nature of the underlying client is to invest in various investment assets. So I will not go through each and every reason as to why we did not find it suspicious, because these were already provided by my colleague. But maybe what I can reiterate is that we did what we are required to do as a prudentially regulated institution. This is what we have been doing all along in servicing this client for the multiple investments that we've been making over the years. On the second question, which is to say, where is our managing director? Unfortunately, our managing director today had already some existing engagements, which were also very pressing, and it made him fail to attend this meeting. But suffice to mention that he had confidence that the team that has come here today would sufficiently address the questions that you would want to raise. And I believe that we have, unless you feel there is a matter that we have not ably addressed, that the MD in his capacity would be able to address beyond what we have addressed. Perhaps that could be written in a letter and an appearance could be made or a response provided. Thank you, Chair.
Thank you so much. And I have all the honor members. Controlling officer, can you switch off your mic? I see a point of order from Katapi Central.
Yes, Chair. The question was a summary, that in summary, the pensions fund has been defrauded, and the fraud occurred through the banks. Money moved from the fund account to use of investments. That's the trail. Now the question is, how do you defend yourself as FDH Bank? How do they defend themselves? Because fraud has occurred. The money is gone. How do they defend themselves?
There's a point of order from Katapi Central. Controlling officer.
Honorable Chair, my colleague, our legal counsel, will take that one.
Please proceed.
Thank you very much, Mr. Chairman. We do not intend to tire this committee with ongoing ramblings of things that we have been saying. But if you can indulge us, allow me to take you back to what we are saying. All it boils down to is what was the duty of the bank in the circumstances. Did the bank receive legitimate instructions from its customer? Did the bank do its due diligence? Did the bank form any suspicion that maybe the transaction was illegitimate? I think we have provided answers to those questions. But probably one thing that I can say is, I think there was a consent from honorable member to say that we had said FTH was a conduit. I know that when we're talking here, conduit may have some sinister connotations, but the way in which my controlling officer said it, she was trying to say, or she was referring to the normal operations of a bank as a provider of financial intermediation. Chair and members, anyone can send money through a bank. Anyone, whether a thief or a scrupulous person, they can send money. But all it boils down to is whether the bank did what it was supposed to do in accordance to the applicable law or its policies. And again, I put it to you, Chair and members, that we did that. We ticked all the boxes. We made sure that we are compliant with AML law, financial crimes law, and we did due diligence to the point that we were able to transact and honor the instructions that we received from the customer that we have. It may be that maybe before giving us the instructions, they did all sorts of things. We cannot know. And I can challenge you, Chair and honorable members, that you are not going to find any bank that can allow to be roped in the discussions that take place before the instructions are made. But what law enforcement authorities are supposed to be concerned with is whether that due diligence was made and whether the instructions were lawfully honored. Thank you, Chair.
Thank you. Chikwawa North, then Mulanje West. I know controlling officer has talked of they ticked all the boxes, but when it comes to the instruction, which was in a sale agreement, which was 30%, that was never ticked. Payment or that it never happened. The bank decided to play blind on the 30% sale agreement, that the payment went on to pay 72% and whatnot. So, but for the sake of progress, let us proceed. Chukwawa North.
So much, Honorable Chairperson. My question will only require a yes or no answer. The controlling officer, can you assure this committee that you fulfilled your role as a financial gatekeeper? If yes, what is your position now to ensure that public funds are well safeguarded? Thank you so much, Honorable Chair.
Thank you so much, Chikwawa North, controlling officer.
Thank you, Honorable Chair. If you may permit me to react on your earlier comment before the Honorable member representing Chikwawa North raised his questions, I would like to do that.
Please proceed.
Thank you, Honorable Chair. With respect to whether we ignored the 30%, as I had indicated within my earlier explanation, the instructions that we received did not say that the payment that we were making were with respect to the 30% or the first installment. This payment could have been in respect of several installments. It was just an instruction to transfer. So on our part, I would not say that we ignored it, because had they said that this is in respect of the first installment, I guarantee you, Chair, that we would have verified in the agreement to see that it matches the first installment. But this was a payment to make, at which stage they were in the discussions or the process of the transaction. At that point, we were not aware. With respect to the questions raised by Honorable Member for Chikwawa North, okay. My colleague here will take it.
Can you switch on the mic?
Thank you very much, Honorable Chair and Honorable members. I think there were two questions. The first one was said to require a yes or no response. But the other part, I think, required an explanation. So on the first one, I can confirm, Chair, that yes, we did our part. And on the second part, where he's asking whether now that we have heard from you on the goings on in this matter, there is something else that we could do. I think, if I can paraphrase it in that way. Chair, under the law, we have duties. And these duties relate to probably some of the information that you are giving you, but also our own records. So the law requires us, whenever issues to do with finance are being investigated or are being handled by various bodies, we are supposed to make sure that we comply with those ongoing obligations. When my colleague in risk, Mr. Apua, was addressing you earlier on, he had indicated that we have been in touch with various bodies, including our own regulator. So those are the things that we are doing, including appearing before you, honorable members. Thank you, Chair.
Thank you so much. Mulanje West.
Thank you, Chair, and all my seniors. I just want to plead with you, Chair, because it seems as if we are just moving in circles. And they are proudly saying the law requires them to comply, but also the law requires us to ask you to give us the evidence. So if that's the case, why can't we have, maybe asking you to have a court order for them to release, because you are afraid of the court or you're afraid of your customers to sue you. And then it's better for us to get that information. We can get a court order for you to give us. There's no way that we're going to be moving around the circles for the whole day, not releasing the information that they're afraid of their customers to sue them, or the law requires them. These are the laws which we also pass in the parliament. You haven't passed your law apart from us. So the law also requires us to ask you. So if that's the case, then why can't you move forward and ask a court order and let them go? So they're going to come and give us information after the court order. Thank you so much.
I see Chikwawa West. Yeah, Chikwawa North.
Person, I wanted to request from you maybe to have a 5 minutes break. Just a break, they go out, and then they come back for our final determination. Thank you.
Thank you so much, but they've responded to first question. We are remaining with 2 more. So maybe we can have a healthy break for 5 minutes. Then we come, they conclude or they handle the 2 more questions, and while the committee can also deliberate, okay, in camera. So yeah, but we'll proceed to have 5 minutes health break. I therefore suspend the proceeding for 5 minutes. Thank you.
Osaiwala kupanga subscribe ku channel ya AMTV Malawi.